Welcome to Employment Law This Week. I'm George Whipple. Religious accommodations take center stage. The current administration released a memo expanding religious accommodations for federal workers to specifically include remote work requests. Epstein Becker Green's Nancy Gunzenhauser-Popper tells us more.
In July 2025, the Office of Personnel Management issued a memo relating to religious liberties and provision of accommodations for federal employees only. A part of this memo encouraged managers of federal employees to be flexible with employees who are seeking religious accommodations. Interestingly, including remote work. This actually contradicts prior memos issued by this administration relating to allowing remote work for federal workers.
The memo cites Groff versus DeJoy, a Supreme Court decision that applies to both public and private employers. This could be a sign that the guidance will pave the way for more scrutiny of private employers in this area.
In 2023, the Supreme Court decided Groff versus DeJoy, which changed the standard for evaluating religious accommodation requests. Both religious and disability accommodations use an undue hardship standard. Religious accommodations had a de minimis cost standard. The standard for religious accommodations has changed, and employers now have a higher bar to deny religious accommodation requests.
Religious accommodation requests are on the rise over the past few years. We asked Nancy how employers should respond.
We've seen religious accommodation requests increase since COVID, and in particular, when COVID vaccines were being required at first by federal and also by state and local laws. Separately, we have also seen accommodation requests increase overall, so whether by religious or by disability or pregnancy, relating to remote work. We will continue to see this increase with this new administration's focus on religious rights. Religious accommodation requests need to be evaluated in the same way that any other accommodation request comes in. Employers need to engage in the interactive process with employees to determine what limitations exist and whether an employer can provide a reasonable accommodation absent an undue hardship. Given the recent case of Groff versus DeJoy, that standard has changed to eliminate the de minimis cost standard.
Thanks, Nancy, and thank you very much for watching. We'll see you next time.